Please be seated. Court now calls consolidated case numbers CV1427 and CV140421, generally entitled United et al. Versus MIHS. Counsel, these proceedings are being recorded. They're also being video recorded, audio and video recorded. I want to advise you that there'll be a link to the court's website following this oral argument within a few days. Please make sure you identify yourself and your client when you commence your argument. Each side has 20 minutes. Appellant may reserve some rebuttal time. We've read the briefs, we've discussed the cases in conference, so we're very familiar with the issues in this case. And you do have the clock on the podium in front of you to keep track of time. Mr. Court, you may proceed.
Thank you, Your Honor. May it please the Court, Robert Court of Brownstein Hyatt Farber Schreck for United Behavioral Health, the appellee in the Maricopa Integrated Health Services case, and the appellant in the MIHS case, as we've called it, and the appellee in the Aurora Behavioral Health. I'd like to reserve 5 minutes for rebuttal time at the end, if I may. In the two separate arbitration demands, or really three demands in the two consolidated cases, the Aurora and MIHS providers dispute UBH's adverse coverage decisions pertaining to 53 individual plan members under 18 separate benefit plans. All but 3 of those adverse coverage decisions was made by UBH pursuant to an ERISA or a Medicare Advantage plan. As the trial court in the Aurora case correctly determined, the provider's claims must be pursued through the mandatory administrative procedures under, as applicable, either ERISA or the Medicare Act, and as expressly stated in the benefit plans themselves, and therefore the claims are not subject to arbitration.
Counsel, can we start at the beginning so I understand who it is that you represent? I mean, I'm looking at our caption. Our caption seems to only include MIHS. What's the relation between MIHS and Aurora?
They are completely separate providers. So what you have is our client, we represent United Behavioral Health, Inc., which is the plan payor. UBH, as it's called, contracts with providers, and you have one set of 2 providers that we refer to as Aurora.
So it's as to, do we have 2 appellees here then?
We are the appellee in the the appellant in the MIH case and the appellee in the Aurora case. The trial court in the Aurora case determined that the claims that were pursued in that case by Aurora were subject to the exclusive administrative procedures under ERISA and the Medicare Act.
I think we maybe need to fix our caption.
We need to add to the caption.
Did the individuals assign their rights to the providers?
They have not. The providers have not acknowledged, and because of the limited record in the trial court below, there's no evidence in the record as to whether there was or was not an assignment. They have not denied that there was an assignment of benefits, which is standard protocol for providers in this type of an instance. And in fact, Your Honor, in the absence of an assignment of benefits, there would be no independent right to pursue these claims, because each of these claims disputes UBH's determination that the specific treatment requested to be authorized, was it or was it not covered?
But counsel, you said that the providers have not denied that they have assignments. I guess I'm missing something here. What's the mystery about whether they have an assignment or not?
I'm not sure there is a mystery, Your Honor. The only point I was making is that because we never progressed to the merits of any of these claims, including even the standing issue in the trial court below, rather focused solely on the arbitration issue, is that there was no evidence submitted in the record of whether there was or was not an assignment of benefits. The only claim they make in the brief is that they're not suing based on any assignment. But as we described in our briefs, these claims are clearly derivative in nature because
Counsel, because arguably if they were suing under the facilities agreement, they wouldn't need an assignment.
correct.
Okay.
They attempt to characterize their claim as what's called a payment dispute, or as the ERISA cases call it, an amount of payment dispute, when in actuality it's a coverage dispute or what we call a right to payment. And that is because the only obligation that UBH has under either of these facility agreements is to pay for, quote, covered services, end quote. And covered services are defined in the facility agreement as services, mental health or substance abuse services that qualify, or I'm sorry, that are that qualify for coverage under the member's benefit, under the terms and conditions of the member's benefit plans, including the determination of medical necessity. In the instances here, what we have is a series of separate instances where a patient comes in for treatment to one of the providers.
Counsel, I want to ask you a question. So is your argument that ERISA and Medicare specifically or expressly preempt the policy, the arbitration clause and the policy under the FAA that strongly favors arbitration? Is that your main argument?
No, I don't think so, Your Honor, because I think what we really have are two separate paths. So if you have a coverage dispute, which is in this case, that's governed by the benefit plans, then you look to the benefit plans themselves. The benefit plans contain no arbitration provision. Moreover, they mandate that any appeals of coverage determinations be pursued through the administrative procedures mandated by ERISA and the Medicare Act. Conversely,
That's a matter of contract.
that's a matter of both, contract in the plan as well as federal regulation that mandates all those disputes be pursued through that way.
But you have to get there. You have to get past this extremely broad language in the arbitration provision that it would resolve, that the parties would resolve any disputes about their business relationship.
Correct, and I would refer, Your Honor, because the case we have that's closest on point, and we cited in the Aurora answering brief, is the recently decided case of CardioNet versus Cigna out of the Third Circuit in May of 2014. Respectfully, that's the only case out of all these cases that have been cited where you have the precise issue here, which is a provider that's bringing the claim, number one, and number two, that the issue to be resolved is, are those provider claims subject to A, the arbitration provision in the provider agreement, or B, the administrative procedures and plan provisions mandated in that case by ERISA. And what the court concluded is that although the provider, like MIHS and Aurora here, attempted to say, no, we only are requiring payment under the facility agreement. What the Third Circuit said, if you look at its rationale, is you may be asking for payment, but the only way you get payment is if it's a covered service under that particular member's plan. And the provisions were virtually identical. They only obligated Cigna, like UBH here, to pay for covered services. So the fundamental question that needs to be determined in each one of these 53 separate member claims.
Yep, I have to go step by step with you, okay? I apologize for cutting
okay.
off, but I'm trying to understand. But then wouldn't the providers argue, in the contract itself, the facilities agreement mentions under section 4.1 and 4.2 and that you have to look to the member's benefit plan to determine what's a covered service. But wouldn't the providers argue that's what you decide in arbitration? In other words, that sort of is beside the point as to what you have to look to and how you resolve it. They want to compel arbitration, and they want an arbitrator to decide that.
Well, and I think to your question earlier, I mean, these ERISA and the Medicare Act contemplates a broad federal scheme of regulations to resolve the issues.
So doesn't it ultimately come back to whether or not Medicare Part C and ERISA preempt this arbitration provision?
In part, Your Honor. I mean, my question wasn't meant to not respond to that. I think there are two separate paths, as I explained, but if you find that the arbitration provision, despite being limited to the facility agreement, potentially applies to coverage determinations, then yes, I think it's clear from the cases that we cited in both ERISA, and I'd refer to CardioNet, and for the Medicare Advantage claims, I'd refer to the ex parte Blue Cross Blue Shield of Alabama case, which Judge Reyes cited in his decision as to why these claims are in fact preempt the arbitration provision to the extent the arbitration provision is broad enough to encompass them.
And this is preemption of the Federal Arbitration Act, right? Or are we talking about Arizona policy favoring arbitration or the Federal Arbitration
Well,
Act?
I think it's preemption of these state law claims that they're attempting to pursue, whether they be through a state court tribunal or pursuant to arbitration. I mean, we don't dispute that the Federal Arbitration Act governs, but that doesn't answer the question of whether these types of claims, which Congress has seen fit to require be pursued through administrative channels, can nevertheless be arbitrated. And I'm sorry.
How many of these claims? You said there's 50?
53, correct.
Are each one of these claims, are the providers seeking payment of benefits? They're just seeking
Yes.
coverage?
Yes, that's precisely
Are
the
they seeking
issue.
anything in addition to that? Any other type of damage?
No.
Anything like that?
No. And
Are there any claims for any other type of tort or breach of contract action for damages in addition to the benefits?
No, they have only sought benefits. Now, they claim under a purported breach of contract case with the contract claim, with the contract being the facility agreements. But as we've pointed out, the facility agreement does not answer the question of whether a claim is covered.
They've alleged a bad faith claim, though, haven't they?
No.
I thought there was a cause of action. So they've not alleged any bad faith delay or bad faith denial, anything like that?
No. These are right to payment claims versus amount of payment.
And so the remedy that all of those claims would be remedied if the coverage was provided, the benefits were paid. Period.
Correct. And I think if you look at sort of the context of how that works, the provider's obligated under the contract to request authorization at the outset. Is this claim covered or not? And these claims fall into two categories. In some, UBH denied coverage at the outset and said this treatment is not medically necessary given this particular member's benefit plan, conditions, and alternative levels of care that are sufficient. In other instances, as they point out, UBH initially authorized, what we're talking about here is primarily acute inpatient care, which is 24-hour supervised inpatient mental health care. In certain of those claims, UBH did authorize a finite number of days of acute inpatient care.
Just so I understand that better, these were all court-ordered Title 36 mental health assessments, right?
I don't know if they all were. Certainly they've alleged that many of them were.
And so what United authorized, there's the initial evaluation, court-ordered evaluation period, and then if there's grounds to have a hearing for a commitment hearing, then they're held over what it takes about a week, I guess. But anyway, and then you have the hearing itself, Title 36 hearing, and then the decision is made by the judge whether or not to commit the person inpatient for a certain number of days. And what United authorized generally was the initial evaluation up to and including the hearing, or is not that clear of a line?
It's not clear, Your Honor. I mean, keep in mind, this is a subset of a much larger set of claims, and they're not based upon what the court ordered or did not order. I mean, that's whether the person qualifies for care. I mean, the question here is it a covered service? Is it medically necessary? And where I was going with that is, although they authorized some for a finite period of days, it's clear that once that finite period of days ends, the provider must request authorization. So it's a brand new episode of treatment. And UBH then denied continued acute inpatient care. And the providers have attempted to argue, well, since they authorized it, we know it's a covered service, and therefore we don't have to resolve the coverage issue. But as we point out, that's not true. And the analogy we drew is almost like a surgery. Just because you perform one surgery that's authorized as medically necessary doesn't mean that automatically any surgery is now authorized and covered under that member's plan. Each treatment...
It's primarily what's medical necessity, is that the...
with respect to these claims, sure. I mean, the primary issues that need to be looked at are enrollment, obviously, and then does it fall within an exempted category of services, and then ultimately, in this case, when you're talking about acute inpatient care, is it medically necessary? And importantly, the facility agreement in explaining what's medically necessary refers directly to the terms, again, it says, except as otherwise required by applicable state or federal law or regulations, for purposes of this agreement, medically necessary means the term as it may be described in the member's benefit plan for MHSA, which are mental health substance abuse services.
Is that section 4.2?
I think it's in the Aurora. The contracts are slightly different. The Aurora contract, I believe it's on page 2. It's not a section number because it's in the definitions. I don't recall if the MIHS has an identical provision in the same place. I'll make one more comment and then try to reserve a couple minutes for rebuttal. The contention, again, focusing on medically necessary, that's not a coverage determination, which is what the providers have argued. We'd submit that it's no different than enrollment, which I described. So if you had, for example, a claim where the service, was medically necessary, but the issue was they denied it because for whatever reason the member was not properly enrolled at that time. Well, that would be no different than this case. That issue would need to be resolved under the benefit plans and pursuant to applicable regulations. And for the providers to argue that that's an agreement that's either contemplated by the facility agreement or that could be arbitrated under the facility agreement would be incorrect, Your Honor, and your panel. And the only difference here is that the coverage issue happens to be medical necessity, which is an individual coverage decision that's made with respect to each individual member under that member's benefit plan. If I may, I'd like to reserve the remaining time for rebuttal.
Mr. Sipperman?
Thank you, Your Honors. May it please the Court, my name is Mark Sifferman from Clark Hill.
Mr. Sifferman, I have a question for you, really kind of out of the gate, okay? How do you resolve whether each of these claims for each of these members were covered services without looking at the Medicare plan or looking at the ERISA plan? Is there any way to resolve it without looking at those documents, whether it's an arbitrator or a judge or whoever?
Yes, Your Honor, and just for the record, I represent Maricopa Integrated Health Service.
I'm sorry, I cut you off so quick. I'm
And the
so
first
anxious to
case-
hear your answer, I could barely contain myself.
I'm not wasting time to think
No,
of
I
the
know.
answer. In Aurora Behavioral Health System and Aurora Behavioral Health Care Tempe, if I might just address Judge Thompson, I'll come back.
Yeah, I was just trying to get the caption straight because we've only got one of the parties named here, and both of you are an appellant and an appellee.
Right. My three clients run acute inpatient behavioral health facilities. Maricopa Integrated Health System is the old Maricopa County Hospital. Aurora Behavioral Health System and Aurora Behavioral Health Tempe, private company, have their own separate inpatient acute care facilities. The commonality is United is the insurance company who's either paying or not paying on this. Addressing Judge Gould's question, yes, we don't have to get to the language in either the Medicare Advantage plans or the ERISA plans, because as counsel has said, and if you imply from what he says, we're talking about medical necessity. The definition of medical necessity, it's a term that can mean different things in different situations. But in this case, it's important to understand what it means in this particular case, because we have in the MIH case, they're all either court-ordered evaluations or court-ordered treatment. All the court-ordered evaluations turn into court-ordered treatment. In the Aurora cases,
Counsel, I've got to bring you back here, because
Okay.
I'm looking at the facility agreement for MIHS, and I believe it's section 4.2, where it says United may deny the requested services on grounds, quote, "they are not medically necessary as defined in the member's benefit contract." How do you resolve whether or not something's medically necessary based on that language without going to the individual member's Medicare contract or benefit plan and looking at what's covered, what's medically necessary? How can you do
are
that?
you talking about the Aurora contract, Your Honor?
Whatever section 4.2 is, I thought that was the MIHS contract, facility agreement. Section 4.1 has the same language. It talks about covered services or services, quote, "covered by the member's benefit contract," end quote.
In the MIHS contract, that is the language in 4.2. The language in the Aurora contract is significantly different. But medically necessary in this context refers back, and in the MIH contract, it talks about you have to provide these in line with United's protocols and provider manuals. And what they refer to is United's level of care guidelines. And we've put those in as appendix to the brief. Because the covered services means, in this context, okay, sometimes we're going to cover inpatient, sometimes we're going to cover intensive outpatient, sometimes we're going to cover residential treatment, which is a step down from inpatient. Those things are broadly covered by the plans. Then they're all defined, everything in insurance, Medicare, ERISA is always defined by, is it medically necessary?
So you're saying that the term medically necessary is either a generic term that doesn't depend on any special definition from Medicare or ERISA, or that the specific determination of medically necessary is going to be made by UBH according to its own criteria?
What I'm saying is medically necessary does not depend on some specific language, or the determination of medically necessary is not determined by specific language in any of the plans. It's an overall concept that's applicable to all the services that may be provided. So anything that the United is going to pay for has to be medically necessary. It's just a fundamental of Medicare.
Well, why does it talk about the member's benefit contract then? Let's back up for a second. This is a Medicare Part C case. We'll talk about those claims first versus the ERISA claims. And the idea there is, unlike traditional Part A or Part B Medicare, Medicare contracts out to United in this case and pays them a capitation rate, pays them per member, and says, we're done now. You take care of it. We're paying you X amount of dollars per participant. You provide the care. But there's also the regulation that says that care that's provided has to be the same as the care that anybody would get for any other Medicare program, specifically Part A or Part B. So the control that Medicare has to make sure that some private insurance company doesn't start shrinking coverages, we're paying you a set rate, but you have to maintain the same standards that people on regular Medicare are provided. And what is the control? What's the mechanism for Medicare to ensure that? Coverage decisions are defined by the Medicare benefit plan, and ultimately the administrative review process for Medicare coverage, it has to be decided by Medicare. Otherwise, what would stop insurance companies from taking the payment for each member and then providing coverage that's nothing like what Medicare coverage is. What control does Medicare have if they don't have this administrative review process to make sure that coverage is the same for Part C participants and Part A and B?
Because when you're talking in, are the Medicare Advantage plans providing the same coverage as under A or B? You're talking about, okay, do we require coverage for inpatient psychiatric care? Yes, it's required across the board. What we're talking about in these cases is United's made the decision that based upon their level of care guidelines, we're going to pay for the first 2 days of the inpatient, but under our guidelines, they should have been sent to a residential treatment center, so we're not going to pay you for the inpatient amount. So to answer your question this is not an instance where Medicare has to get involved to make sure that everybody provides the same coverage. We're on the very specific instance as to individual patients, whether this qualifies under United's guidelines
Counsel,
for inpatient.
Are you telling me that it doesn't matter to Medicare whether acute inpatient care for members is medically necessary? That that's not something that Medicare is concerned about in terms of ensuring the same level of care?
Your Honor, the answer to that is that I think the answer is they don't care in the sense of they have not set up, there's no provision for a Medicare administrative procedure to determine Medicare Advantage claims asserted by a contracted provider against a Medicare Advantage organization like United. That's what RenCare says, that's what Krista says.
To use the Supreme Court's language, isn't that inextricably intertwined with Medicare's policy? Its intent is to ensure that there's the same level of care? How can that not be inextricably intertwined? That whether inpatient or acute inpatient care for people who are suffering from mental illness, mental diseases, so forth, whether that's medically necessary or not, how can that be anything other than inextricably intertwined with Medicare's policy that they're going to make sure that there's the same coverage under Medicare Part C as Parts A and B?
Well, what I can tell you, Your Honor, is that we know that the Center for Medicaid and Medicare and Medicaid CMS has stated, and we have quoted it, they provided an amicus brief in Christus, and they have provided a letter to the court in that case saying when it's a Medicare Advantage situation, Part C, we don't have a procedure to deal with a dispute between insurer under a Medicaid Advantage plan and a contracted provider.
But
So,
that case dealt with a different kind of dispute. That was a true business dispute. I think that was the case. I may be mistaken. That wasn't a coverage case, Christus. That was a different. It wasn't that wasn't a dispute over whether or not there was coverage for the member. That was dealing, I think, with a group of physicians or something in the group and what they were being paid, what they were being reimbursed under Medicare.
Well, the RenCare case clearly was whether or not a particular procedure was going to be paid for.
But that was a case where the procedure by the, I think it may have been United, but whoever the contractor was, they had said, this is covered. We're authorizing this. It's covered. We're certifying this. But we disagree about what you should be reimbursed for it. That's a different issue, because when you look at these contracts and you look at the coverage issue is, are we going to pay for this benefit or not? Is this something we pay for or not? Versus how much we should pay, or the delay in paying. Those are different kinds of disputes, aren't they, counsel?
Your Honor, the problem is the coverage and benefit, again, are terms that are used in different situations. And in this one, we are not talking about is the patient covered for acute inpatient care? Because they are, because they did receive it. This is not a situation where they were denied a service. That's why there's no assignment of the benefits. So this is a situation where we are arguing about.
Counsel, but they authorized You know that the provision in the agreement is you have to get written authorization for any care beforehand, unless it's an emergency. And they authorized X number of days. And it was clear that you couldn't get additional time and care unless they authorized that as well. And what happened here was the time ran out that they authorized. And then when it came for the request for continued care, they denied it. That's not a coverage issue?
Not in this context, Your Honor. This is one that is on the other end of the spectrum. It is a how much do you pay? Because the denial letters that we put into the appendix of the brief, they deny days of inpatient care based upon their published level of care guidelines, and they say they shouldn't have been inpatient. They should have been in a step-down facility.
If I go to a hospital and they authorize 3 days in the hospital for me, but won't authorize a 4th day, isn't that a coverage issue?
Your Honor, under these cases, we believe not. But even if they are, Your Honor, let me go back to a question you asked counsel first, which is basically who decides what rules? Is it the arbitrator or is it a court? And even if, I'd rather not have to go to the arbitrator to argue, okay, does Medicare preempt these claims, or does ERISA preempt these claims, or is there some process? I believe that the U.S. Supreme Court's cases say those issues are for the arbitrator, because we have provided that disputes about our business relationship get decided in arbitration. Because what the Supreme Court gets a little testy about, and they did with the Oklahoma Supreme Court, is when you start looking at the substance. Is it is it interrelated with Medicare? Is it, in the Oklahoma case, is this a contract, restrictive covenant of employment? If you start looking at that level, you've missed the point, because under the FAA, it goes to the arbitrator. Those decisions, all those things, once you decide that the contract provision covers this dispute, then all the other decisions are for the arbitrator. And let me address CardioNet, because that one, correctly understood, supports our position. CardioNet, specifically, yes, it was claims by healthcare providers. What had happened was that Cigna had covered a certain treatment by a medical device, and then they decided not to. And then Cigna sent out a advisory saying, we think this is exploratory or experimental, we're not going to cover it anymore. 4 claims that were brought by the health providers were claims that were specifically assigned by patients who were denied coverage. And the reason the arbitration provision didn't cover those is because the provider were relying on an arbitration provision in their facility agreement with the insurer. These claims weren't arising out of that agreement. They were arising out of whatever benefit plan those patients had. So the court said, you can't import that agreement, that arbitration provision, into this one. And then the remaining claims had to do with claims by the providers that physician update tortiously interfered or violated the Lanham Act or were trade libels. And the court said, wait a second, that's not within your arbitration provision. So the reason CardioNet is not helpful to us is because we have significantly different situation. We have a broad provision in a facility agreement which the providers are asserting claims under. And that's why the question you asked was, are there assignments of claims? No, we're not derivative claims. These are claims under the facility agreement. And therefore, that provision, the arbitration provision, applies.
What I think I'm hearing is you're saying that the treatment was medically necessary and would have otherwise been covered except for United's minimalist view of where it should have been covered at.
Yes, Your Honor, their interpretation of
Their interpretation
their level of care guidelines.
and not whether or not there should have been care.
Correct. There should have been care. They're just saying there should have been care somewhere else, at another facility that's not as acute.
Are you seeking any damages in addition to the provision of the benefits? Other than attorney's fees or those types of things, but in terms of your damages, are you seeking that the benefits be restored, that the benefits be paid?
We are not seeking any extra contract remedy. We are seeking payment at the acute rate for the days that were not paid by United.
And
So
the
it's a
care-
dollar amount.
And the care was already provided, right?
Correct.
Despite the denial.
Correct. Your Honors, unless you have another question, I think the briefs have covered everything.
Thank you,
Thank you.
counsel. Mr. Court?
Thank you. With respect to one point, the Christus case, just for a clarification, clearly you're correct, Your Honor, was not a coverage case at all. The case you were describing, I think, was actually the Kirby case, which also was not a coverage case because it involved a dispute between partners who just happened to be receiving some Medicare revenue, but the Christus case similarly had no coverage.
Yeah, I start with those same consonant sounds and I mix them up, so.
Yeah, in Christus, actually, the only real issue was the plan administrator went insolvent, and the court just simply needed to decide if the plan was vicariously liable for the admittedly covered claims that the plan administrator was now incapable of paying because of its insolvency. With respect to your initial question, Your Honor was exactly right with the fact that medical necessity clearly cannot be answered without looking at the plans of each member, and that applies to both the MIHS, and you cited Section 4.2, and counsel suggested that the Aurora contract was different, but it's actually even more direct, Your Honor, because in Aurora, under Section 3.1, it states that UBH shall pay only for covered services, which is a defined term. Then if you look at the definition section beginning on page 1 of the Aurora contract, covered services are defined as MHSA, which is mental health substance abuse, services that meet the terms and conditions for coverage pursuant to the member's benefit plan, including such conditions as medically necessary and proper authorization. Then it even, as I mentioned earlier, even goes on to define medically necessary as medically necessary means the term as it may be described in the member's benefit plan. So the fact that some of these medical necessity determinations may over time follow certain patterns or protocols doesn't matter. You still have to look first and foremost to the particular benefit plan and what it calls for. And secondly, again, the Medicare regulations also govern the Medicare Advantage plans in determining and issuing guidelines as to what can and cannot be medically necessary in certain particular instances. And Medicare Advantage plans need to follow those regulations. The last point I'll make with respect to CardioNet, I think a review of that case in the ERISA context confirms that it is clearly on all fours. I mean, the provider there tried to argue, just as Aurora does here, that these are not derivative claims, that we're only suing under the facility agreement. And no matter whether they say that or what they call it, The court has to look to what creates the obligation to provide coverage. The facility agreement does not do that. The only document that does that is the plan, and then you also have the fact that the applicable federal regulations govern those determinations as well. Thank you.
All right, thank you both. Council will take this matter under advisement and will issue a written decision in due course. Court's in recess.